rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. So we are here on our case number 1CACV170363, STITH versus the ENSIGN Group, Inc. So counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. You need to keep track of it for yourself. We record these proceedings, so would you please, when you approach the podium, give us your name and the name of your client for the recording. We have read the briefs, we've studied the record, and we've also discussed the case in our conference. So with that, you may proceed.
Morning, Your Honors. May it please the Court, my name is Scott Boehm. I'm appellate counsel for plaintiff Peggy Stith. We're here today to have the Court tell us what the first sentence in this arbitration agreement says. And if it says what defendants argued in their motion to compel arbitration, then we have other issues on whether it's nevertheless unenforceable due to ambiguity and several other enforcement defenses. But if the Court agrees with our position that the plain language excludes all of the claims the plaintiff made in this case, then we're done. So our lead argument kind of is the controlling argument, and if you agree with that, we're golden. If not, then we have to move on to the others. Ultimately, I think the interpretation comes down to whether this first sentence contains one or five exceptions to the arbitration requirement, and more specifically than that even, what about these missing commas in the first sentence? I think three things about that are important, I think, that will help the Court, that we both agree on. One is that all five of plaintiff's claims, med-mal, APSA, intentional infliction, negligent training, and punitive damages. All of those claims depend on the same allegations of medical malpractice against Peggy on May 12 over to 13 of 2014. There's not some facts on some facts on others. Everything kind of stems from her falling or being dropped on her head, and then the failure to figure out she had
some additional facts maybe for the other claims, but they all turn.
Yeah, everything stems from what happened over that night. The second important thing, I think, that we both agree on is that interpretation of the contract, including ambiguity, is a legal question for the Court. So, de novo review anyway. We don't have to worry about any fact-finding, and frankly, there's no factual disputes that are at issue anyway. And third, and this maybe sounds kind of crazy, that given the issues here, is that both the defendants and we agree that the plain language of the contract controls. We disagree as to what the plain language says, but everyone agrees that the primary principle applicable to both statutory and contractual interpretation is the plain language. And our main argument is that the plain language simply does not say what they claim it says. If you look at the title of it, I guess I conceded in my brief, I'll concede again, they probably intended to accept from arbitration only med-mal claims, but they didn't do it.
So, yeah, so that's what makes this kind of odd. We're lawyers. We understand the purpose for an arbitration agreement is to push stuff to arbitration. So we can understand that the author of the agreement probably intended to exclude only claims for med-mal from arbitration. But, and if one wanted to do that, one would have put in a couple of commas here that don't exist.
Yeah.
So if we as a court and counsel understand that, why shouldn't we interpret it as if there were commas?
Because the controlling case law is that the court can't imply or pretend or imagine that the contract says something that it plainly doesn't. And I've discussed a litany of cases in my brief about you can't add words, you can't interpret words other than their plain meaning. This isn't a words case, this is a punctuation case.
But if it's just a punctuation case and we can tell, the rest of the sentence, the very long sentence, doesn't really make any sense if you don't put in those commas. You could read it, other than a claim for medical malpractice, you don't necessarily have to put the comma there. It would still make sense to at least be saying, other than a claim for medical malpractice arising out of the provision of services by the facility.
Correct. And that's certainly the way I read it.
And then, so you put a period there, but what does the rest of, if we can read it and just say, no one reading that would do anything other than put a comma, although we would have to say right after claim and right after malpractice.
Exactly. You have to rewrite the contract, which the court can't do. And I disagree with your premise there, and hopefully you're just devil's advocating that. I don't think we can say that anybody reading this would pretend there's commas there.
Well, no, but anyone reading it would say that the rest of the clause, the rest of the sentence doesn't stand alone, and you can't.
I think it does.
To have any meaning at all, you have to have intended a comma there.
I simply disagree with that. I think if you read, and I'll read it here once. I mean, it's a long sentence. We don't want to keep going over this, but I'll read it once. Any claim other than a claim for medical malpractice arising out of the provision of services by the facility, the admission agreement, the validity, interpretation, construction, performance, and enforcement thereof, or which alleges violations of APSA, or which seeks punitive damages or attorney's fees. So if you read it without the commas, as it's written, it very clearly and unequivocally states 5 exceptions. And obviously, if there were commas there, if the court, if the drafter, and it wasn't Mr. Ryan, so I'm not taking pot shots at him over here, but if the drafter had put the pretend commas in there, we wouldn't be here on this, because then it would say what they probably intended it to say. But absent those, it very clearly includes 5 exceptions to the arbitration requirement.
But you have to read it to say arising out of the validity, interpretation, construction, performance, and enforcement thereof, without the comma. So I'm not sure I necessarily come up with 5 exceptions. It seems like an odd construction to do that. If it's arising out of 1, the provision of services arising out of the admission agreement, and then that third one, arising out of the validity, interpretation, construction, performance, enforcement thereof, which alleges violations, that doesn't make any sense to me.
That's not a parallel construct.
Right. I guess there would have to be some kind of, if you're writing this to, let's say you intended to have 5 exceptions, you probably would have some kind of a transition, either for the admission agreement or under the admission agreement or something there. But I think as you read it, and whoever wrote this did a PP job on it, but the court is stuck with what it's stuck with.
Okay.
And go ahead. I'm sorry.
I was just going to say, okay, so that's the contract. Everyone agrees, both sides do agree that the agreement excludes claims for med-mal. Under Cornerstone, is it your contention that an APSA claim that's based on med-mal should be treated as a med-mal claim for this under this contract? Yeah,
and I think Cornerstone even goes farther than that. The answer to your question is yes. What Cornerstone stands for, and I was the losing lawyer on this argument, it stands for the idea that if the factual premise of claims are medical malpractice, then they are medical malpractice claims, whether you call them APSA claims or, in this case, intentional infliction or negligent supervision, that if they arise out of medical malpractice facts, they're medical malpractice claims. What happened in Cornerstone is my client in that case, I was the appellate counsel, my client in that case, the trial lawyers, had a nurse who they weren't sure was going to satisfy the touchstones under 12-2604 for standard of care testimony for medical malpractice claims. So we came up with this great idea of let's not allege a medical malpractice claims, because typically what happens is in cases like this where there's med mal and APSA, you allege both claims. Well, we decided that let's just allege an APSA claim, then we don't have to deal with 2604. And we got that by a couple of trial judges, including Judge Marner in the Cornerstone case, but the defendant took a special action. And my argument there, as it had been previously based on McGill, because McGill's been changed now too in Delgado. But back then, McGill was very clear in saying you can have med mal and you can also have APSA. Well, I claimed that they were separate and distinct. And just because it happened with medical malpractice, an APSA claim is an APSA claim and a med mal claim is a med mal claim. And Judge Vasquez down in Tucson basically said, "Bam, you're all wet on that." And the opinion very clearly says that if you allege medical malpractice, if you can call it macaroni, but it's a medical malpractice claim, so you have to satisfy the medical malpractice touchstones under 2604 and all of the other ones. Jumping forward to this case, the problem that arises in that Ilya, Ms. Lerma's in the courtroom trial counsel, presented to the trial judge is that how the heck do we figure out what's going to be arbitrated and what's not going to be arbitrated as a medical malpractice claim, when in fact, under Cornerstone, everything's a medical malpractice claim because they all arise out of the medical malpractice allegations, which again they deny factually, but that's what the allegations are, and they're litanized in the first 30 paragraphs of the complaint. So that creates blatant ambiguity as to what even assuming that the court could add these missing commas, rewrite the paragraph, and even assuming the court could find that if it could be read both ways, which I think is their best argument, that just creates ambiguity for that. And go ahead, guys.
As a practical matter, I'm perplexed by the problems of issue preclusion. If you've got an arbitration going forward on APSA that is going to resolve factually the same issues that are going to be resolved on your med mal claim, so there's a race to get a factual determination.
Yeah, and what about punies?
Well,
I mean, there's punies under under APSA,
well, yeah.
and there's punies under the medical malpractice claim. So we've got, the contract, I think, in my construction, excludes punitive damages. But if it doesn't, then we've got punitive damages in both. And we've got
I had kind of a similar question, just as kind of a practical matter, even without Cornerstone. If the entire argument turns on the allegations underlying the medical malpractice claim, how could you go forward with the arbitration? You're saying it would be possible to go forward with the arbitration. I'm just free associating here, but I'm not sure there's issue preclusion based on an arbitration. But wouldn't the more logical approach be to say, well, we can't arbitrate these claims until there's been a resolution of the medical malpractice issue?
I guess, and I hate to answer this way, maybe, because there's case law out there that Mr. Ryan cited that says you can arbitrate some claims while simultaneously litigating other. The classic example of that, and this came down, the Duenas case was one of these, where you have APSA or negligence cases coupled with a wrongful death case. And when there's a wrongful death case, even if you have a binding arbitration agreement, it's not binding on the beneficiaries. So the the cases say, and I think Duenas even says that, which was another appeal of mine. It says that the arbitration can go forward on the APSA stuff because the agreement in that case was otherwise enforceable. But simultaneously, you have to litigate the wrongful death case because the beneficiaries aren't bound. Now what's left there is exactly what you're pointing out here. How the hell do we do that? Because in this case, the judge said, we're going to discover everything at once, but then MedMal goes over here to trial, and APSA goes over here to arbitration. The judge's ruling doesn't even mention intentional infliction. It doesn't mention the negligent supervision. It doesn't mention punities.
Let's say, is it possible or conceivable that you could, let's say they're going at the same time. Can you resolve the arbitration? Would that necessarily result in issue preclusion in the MedMal case?
I don't know how it would, because you don't have a judicial determination.
So I'm not following, and again, I guess this is more a point for your opposing counsel. What's the point of going forward with the other than, I guess you could get a contrary ruling, you couldn't revisit that in the
There certainly
in the
could be.
arbitration?
There certainly could be inconsistent rulings, and if you just have an arbitration, an arbitration ruling doesn't have res judicata or collateral estoppel effects because there's no court involved, which is the whole nature of it. So it seems to me that, and all of this that we're discussing in the problems forgets the idea of figuring out what's a medical malpractice claim and what's an APSA claim. Because if the APSA claim under Cornerstone is a medical malpractice claim, best case we got here is ambiguity. Because then, as I argued in my brief, if you read the contract the way they want to read it, it says, again, APSA being a medical malpractice claim under Cornerstone, it says medical malpractice is accepted from arbitration, and medical malpractice as an APSA claim has to be litigated, or arbitrated, excuse me. That's blatantly inconsistent. I'm going to stop now because Mr. Ryan didn't address a lot of these issues in his brief, so I'd like to see what he says before I come back up. Thank you very much.
Good morning.
Morning.
The word that I think most struck me when Mr. Boehm was arguing was intended, what the parties intended. And I want to come back to that, but before I do that, I don't want to waive my waiver argument.
Got it.
Because this really was not addressed before Judge Brnovich at all. None of it was. And I think the Campbell case is very clear. That was a contract case, a contract interpretation case. And this court said we're not going to consider any of that because it was not raised before the trial judge. And if you don't raise it before the trial judge, it's waived. So I won't speak further to that, but certainly this information, the whole appeal, is based on materials that were never discussed. The first sentence of the contract, as Mr. Boehm is arguing here in this appeal, which is his whole focus, was never discussed before her at all. So that moves us to looking at that and what is the language before this court. And Mr. Boehm also conceded that the title, arbitration of dispute other than medical malpractice cases, is important, and it is. Essentially, if you take the title, that's excluding only medical malpractice, and all other claims are going to arbitration. Now, if you look at the language here and you interpret any claim other than a claim for medical malpractice as an independent clause, and you read that, that claim is going to arbitration. The next, the admission agreement, that claim is going to arbitration. APSA claims, it is going to arbitration. Punitive damages claims, it is going to arbitration. All claims other than the medical malpractice claim is going to arbitration.
So it would turn, you're saying it would turn it on its head. It would.
Absolutely, Your Honor, absolutely. And this court pointed out that, statutory construction is not that much different than interpreting contractual language. This court has held in several cases that the court is not going to interpret a statute in such a way that leads to an absurd result. Well, can this court?
But this is the contract. The parties
It
are
is.
stuck with what the drafter of the contract did.
While that is true, if there's ambiguity, Taylor, and I'm not going to pronounce this correctly, Grosvenor, that's the best I can do, both of those cases hold that it's the intent of the parties, which really wasn't developed before Judge Brnovich very much, because this simply wasn't an issue until it was raised on appeal. So that wasn't developed at all. The intent of the parties is the controlling factor. And so we have to look, what did the parties intend by this? It would be an absurdity to say that they intended to exclude from arbitration punitive damages. It would be an absurdity to say that...
Not from the perspective of the patient.
Let's talk retrospectively and prospectively, Your Honor. I think that's what we have to do. Prospectively, that isn't necessarily the case. These arbitrations are faster. They get things done quicker. They're less emotionally charged than going before a jury. You know, there's a lot of reasons to go to arbitration. I mean, this isn't part of the record, but I kind of wonder why these are fought so heavily, because it really is a much less threatening environment. So prospectively, Your Honor, if you look at it from when the contract was entered, not at all. Now, retrospectively, if something happens and you want to bring a punitive damages claim, sure. You know, from the perspective of the resident, then you're going to say, yeah, I wouldn't have wanted that. But that's all hindsight. The whole thing is, if you look at the intent of the parties, which again isn't developed, that's not something we've really got a lot for this court to look at because it wasn't an issue. But just from a commonsensical standpoint, you wouldn't exclude everything. These are all the claims that would be made.
So would it require some sort of testimony from the other side saying that's not what I intended to exclude?
That could be the case, but importantly as well, it would be, and this was held at an evidentiary hearing, it would be the person discussing what this arbitration agreement before the signature, Jenna Palacio, from the facility, and what was mentioned. Certainly, that would show the intent of the parties. And that simply was not developed. So one option, of course, is to, if this court believes that there's some ambiguity that needs to be further developed, then a remand to kind of allow that to occur. But as far as the interpretation of this contract, I'm going to make a concession here. It is ambiguous. The language is ambiguous.
You're suggesting it needs 2 commas?
I'm suggesting it needs 2 commas or a parenthetical. I think I probably would have written it with a parenthetical around other than medical malpractice claims, and I would have put an including in front of the rest of the claims, because that's what it means.
Saying that there was a title to it that specifically said, that referenced medical malpractice.
Yes. Yes, and that the title is really important because it's saying other than medical malpractice, any claim other than medical malpractice, and that was the intent. And then by adding the including before the admission agreement and the remainder of them, you're just kind of saying, okay, all claims, but we're specifically mentioning these. That was the intent of the agreement, and I think the evidence would show that. But again, Your Honor, clearly in this particular case, to say that it excludes all of these things would be tantamount to saying, well, you're excluding everything that would ever happen in a nursing home setting from arbitration. So why have the resident even sign it? I mean, it's like it's signing nothing. And that's what they're arguing.
Well, I can fathom up some claims that would not be listed here, but, non-med mal sort of claims, mistreatment, blatant, intentional infliction of emotional distress claims,
Yeah.
maybe, based on something other than med mal.
Intentional infliction of emotional distress, and actually APSA, the statute, has as one of its components intentional harm. No, wait a second, missing it. It's injury caused by intentional acts. So there's different definitions under APSA. But the bottom line is the claims would be few and far between. I can too. I mean, there could be a defamation or some weird claim, but these are the ones that typically arise. And this court has seen many arbitration agreements. These are the ones that typically are included. So to say they're all excluded is essentially not consistent with what the intent of the parties would be, and that would be our argument on that. Now, I'm running out of time, so let me just move, if I could, to the, and I think it's important to talk about this, the Cornerstone case. Because that case does not say what Mr. Rehm says it says. And, in fact, in McGill, McGill said this, that the APSA claim and the medical malpractice claim are not mutually exclusive claims. That's the concept that both of those cases established. Cornerstone followed that. But APSA stands independent. APSA is not limited by any other civil remedy. So it's an independent claim that can be based upon medical malpractice, and that's the abuse component. Injury caused by negligent acts or omissions is one of the definitions of abuse under APSA. So you can base your claim on that because it's statutory, and the Delgado case supports that. But you can't say that they're one and the same because they aren't. That was argued in McGill, if this court will remember. They tried to get the whole APSA claim dismissed, saying it was precluded by the Medical Malpractice Act.
But after Delgado and Cornerstone, how do the elements of the APSA claim that Ms. Stith would bring here differ from the elements of a med mal claim that she would bring? How are they different?
That's an excellent question. They aren't. They're exactly the same, and we on the defense bar hate that. We wish the legislature would change it.
Well, don't you like, though, that she needs to have an affidavit?
We do like that.
Okay.
Thank you for that. We appreciate that very much.
On the intentional infliction claim, aren't you going to argue in arbitration that she needs to have an affidavit?
On the intentional infliction, no, because that's not a component of intentional infliction.
Even though it's based on, counsel says, the same set of facts?
Exactly.
How about the negligent training? Would she need to have an affidavit for that?
Yes, absolutely.
Okay.
The negligent training is part of a medical malpractice component. That's part of a medical malpractice claim.
So why isn't the negligent training claim subsumed within the exclusion for med mal claims as you read the arbitration agreement?
Because it's not a med mal claim. It's based on the same items of proof, which many claims are based on the same items of proof, but they're separate claims. Otherwise, and that's what actually the legislature tried to do. In ARS section 12-562, it said other than medical negligence, you can't bring any other claim. So it would be, and there was like a battery component to that, and it was ultimately held that that was a common law claim, and it was unconstitutional to disallow that to being brought. So they're different claims based on the same items of proof, the same elements, and that's the same with APSA. It's a different claim. It's a statutory claim that was created by the legislature.
So if you've got, so we got at least 3 claims here, 3 of the 4 or 5 that are alleged have the same elements of proof: med mal, APSA, and negligent training. In a situation like this, where the court has ordered 2 of the 3 to arbitration, and actually I called up a restatement section that says if you have an arbitration that has all the elements of judicial fact finding, that's going to have issue preclusion effect. How does that work? And how is that fair? Is that really a rush to judgment then on the two parallel tracks?
Your Honor, no, because that was what the arbitration was contracted to do. So if they bring separate claims that rely on the same elements, then that's what's going to happen. And I would like to correct the record on one thing that Mr. Bain said, and that is, he said punitive damages would be in either one. That's wrong. That was sent to arbitration. The only one that wasn't was medical malpractice. So punitive damages was sent to arbitration as well. So what you have then is you will have issue preclusion on those elements of proof that are the same.
So whoever gets to the end first wins?
Well,
Gets to have that issue decided?
well, the council have solved that issue, and we've stayed the medical malpractice case until such time as the arbitration is resolved if this court affirms the arbitration. So that's stayed. And so we're going to arbitrate first if this arbitration.
Wait, say that again?
Doesn't the arbitration, wouldn't that then preclude any, if the arbitrator concludes that there was no medical malpractice, doesn't that go away? It seems more logical to do it the other way around, to do the medical malpractice case first and then arbitrate the.
Well, but the other way is true too. If we lose at arbitration, then we're also precluded from an issue standpoint. So both sides have the same risk in
I'm
that.
not sure I understood your first sentence. I just wasn't hearing it right. So you stayed the med mal in the Superior Court.
Yes,
And agreed to go forward with the arbitration.
right. If this court affirms, which of course I believe the court should affirm, then we would go forward with the arbitration and the other one would be stayed.
The negligent training, couldn't there be some negligent training that's a little bit different than, aren't there some additional elements apart from just the malpractice in this case? Could you establish negligent training without showing the malpractice?
No.
In this particular case, there would have to be
the show, and that's a great point, Your Honor. Actually, it's almost like a vicarious type claim, because without a tort by the agent, you can't have a negligent training. So if, for example, there is found to be no medical negligence at all by any of our agents, then by definition, the negligent training, hiring, all of that goes out the window. You can't bring, it's totally dependent on a tort being committed by an agent.
So under that rationale, then, one of the issues to be decided in arbitrating the negligent training would be whether there was medical malpractice.
Absolutely. Whether there was medical negligence. And what we would argue in arbitration, as we would argue in the Superior Court if there was no arbitration clause, is that intentional infliction has a high threshold, it should be gone, punitive damages. We're going to do all those same things in arbitration that we would do in the Superior Court.
Has the I understand the arbitration agreement to be a form contract that the company used more than once.
Yes.
Has the issue of its interpretation been ever litigated anywhere else?
You know, I'm glad that you asked that, because honestly, we've been litigating this form and nothing has arisen until very recently in Wilkes and McHugh case. It was raised for the first time that this was ambiguous and should have commas. That's the first time it's ever been raised. We've been in the Superior Courts. These have been consistently, if there isn't any type of unconscionability, if there was no unconscionability, the language has never been challenged. This is not the first time, but the first time happened very recently.
Is that a reported decision?
No, it's a minute entry. It's a trial court, so we don't have anything from this court that has been litigated relating to this language.
Okay.
Unless the court has further questions, I don't think I have further argument.
Well, good. Thank you.
Thank you very much.
take Mike's 3 minutes in addition to mine.
I don't think that's how it works.
The waiver argument, I think, is resolved by Laristis. I don't want to, I'm running short of time, but I cited this in the reply
But I
brief.
actually would like to explore it just a little bit.
You're the boss.
Given the heading on the agreement, and if our job is to try to interpret it to carry out the intent of the parties, if there has been no question, if your client had raised this below, would it have been appropriate for the judge to have said, okay, well, let's have an evidentiary hearing. Tell me what your interpretation of this means. And if your client said, yeah, I understood that it only accepted medical malpractice, would the court not enforce the provision?
The reason that wasn't done is, frankly, is because my client has a brain injury. She has no recollection of anything to do with this. So she could, but the key, I think, is,
But let's say, wouldn't counsel be aware of that? Wouldn't counsel say, this wasn't, my client didn't agree to anything other than?
Well, counsel couldn't testify, and counsel didn't know what the client understood or intended at that time. And I think that the key to all this, though, a couple of things. One is it's the party's intent. All the caption says, and now that Mr. Ryan and this...
Let's say there hadn't been a brain injury or any kind of cognitive problem. Would the ordinary way to handle this be to have the parties each say, this is what I intended the contract to be?
When there's ambiguity, and we've now got a concession that this contract is ambiguous, and the remedy for an ambiguous contract is not to enforce it how the drafter intended it to be. And that's all we've heard from is what the drafter intended.
He said the clause. I'm not sure he stipulated that it's ambiguous when you read it in conjunction with the heading.
Oh, no, but the heading doesn't mean anything. Because the cases I cite at page 50 in my opening brief said the heading doesn't mean a darn thing. I mean, I could agree to sell Judge Johnson my car and the heading of a contract, but if the contract itself says I'm selling her a motorcycle and a Winnebago, it's got nothing to do with the car. And that's the whole point. Both in statutes too. The caption and what whoever drafted the thing put in the caption has nothing to do with what the terms say, and what the parties intended, because which gets and you know we have other issues arise out of this same thing. Is my reasonable expectations argument, my unconscionability argument, both substantive and procedural, all rest on the premise that this is an ambiguous contract. How is it reasonable to expect a woman under the influence of Percocet and Valium to have to sign a contract that the drafter now concedes is ambiguous and bind her to what they want you to rewrite it to say? Ultimately, it all kind of circles back to the principle that this court can't rewrite contracts. If there's an ambiguous contract, which they've now admitted, and I'm still thinking it's not ambiguous in favor of my 5 exceptions, but assuming we at least have a concession of ambiguity, the remedy for that is not to have the court rewrite it, put in a couple of commas, so it ends up screwing my client when she had absolutely no idea that it was going to be interpreted or applied to waive her rights, contrary to the plain language of in my view, of the agreement, by the court rewriting it. I mean, they wrote this doggone thing. Yes, it is a boilerplate thing. It was written in 2005. And the Wilson McHugh case, if that ever does get up here, it's just a trial court case. They're one of my clients. I'm guessing I'll be back here talking to you again about that. But this is a first impression case on this, admittedly now, ambiguous contract. I'm out of time. Thank you all very much.
Thank you. Thanks to both sides for your argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.